Hi guys, okay, just a very quick synopsis on the equity syllabus for the FE1 paper. So from the outset, I suppose it's important to say that the equity exam, as opposed to some of the other exams, particularly I lecture on the constitutional law exam, very different to that type of exam, in that the examiner is very fair, doesn't tend to deviate that much from topics which he likes, and tends to actually put identical questions on papers year in, year out. So from that perspective, there is nothing difficult about it. Students shouldn't get bogged down in the idea that equity is some strange class of subject just because the terminology is different to what they would ordinarily associate with law. Equity is very simple. The core ideas are what is just and what is fair. And equitable remedies have grown up simply because the common law didn't deal sufficiently or didn't provide, if you like, adequate remedies. At common law, all you could get was damages. So therefore, equity developed, I suppose, as a way to provide alternative remedies. Things like injunctions, specific performance, rescission, rectification, creation of trusts. They all developed by virtue of equity. As a result of that, we now have substantial remedies available in law for people where damages simply would not be an adequate remedy, or money just wouldn't fix the problem that they have. They want something else. You'll see on the slides, the examiner isn't out to trick students. His paper is fair. It's a very short manual. There's nothing complex in it. All he wants is for you to get to grips with the basics of equity and apply them to the problem questions that he presents. What's hot and what's not? Injunctions. Injunctions are always hot. Injunctions are simply designed to stop a person from doing something or force a person to do something. When we talk about injunctions, we have to approach them like a type of maths problem, because what we have to do is we have to classify them. And trust me, I hate maths as well. So they're not as difficult as maths. They're actually quite simple when you get to grips with them. So what you have to do with injunctions is classify them according to their function and their duration. So what we mean by their function is, well, are they designed to stop someone from doing something, or to force somebody to do something? And in relation to their duration, how long do they last? Do we look for them on what we call an ad interim basis, which is because the proposed wrong is going to happen tomorrow? They're going to knock down my wall tomorrow. I need the injunction tonight. That's an ad interim basis. It means that the other side aren't on notice. They're not aware that you're going in. They're stopping the person from doing the act until such time as you can put them on notice and the judge can hear both sides of the story. Or do we look for it at the interlocutory stage of proceedings? That is, from the time that you institute proceedings to the time that the case comes on for trial, everything that happens in between is called an interlocutory application. So do we look for an interlocutory injunction and or a perpetual injunction? A perpetual injunction is what a judge will order at the trial of the action, and it means that what he has ordered, so the mandatory obligation or the prohibition, if you like, lasts forever going forward. It is perpetual. I've talked about their form and duration there. Also, we talk about quia timet injunctions being the anticipatory breach. So you'd class an injunction also as quia timet or non-quia timet. You're anticipating the wrong, they're going to knock down my wall, or they have done something, they've knocked down my wall, I want them to rebuild my wall, okay, which is a non-quia timet injunction because it's already happened. You're not anticipating it happening, they've already started the quarrying, for example, okay? And then finally, we look at Moreva injunctions and Anton Pillar orders. And I've said that Anton Pillar orders are incredibly important for this exam, as are Moreva injunctions and all the other injunctions, in light of everything that has happened in relation to Console and the charity scandals and the recent publications. It becomes a very contemporary issue. Specific performance is another type of equitable remedy, and basically all you're asking is that the person specifically perform their obligations under the contract. They do, so you identify a valid agreement, and then you are asking them to simply do what they were supposed to do. I gave you €50,000, you promised to give me your painting. You haven't given me your painting. Damages are not adequate because it's a painting of my grandmother and it means a lot to me and I want that painting. Therefore, what you're saying is I want you to specifically perform your obligations under the contract, to give me the painting which I have given you the money for. Okay. We also talk about specific performance, contracts for personal service and contracts requiring supervision, so forcing a person to work for another person. We talk about how the courts are very reluctant to do that because it involves, or generally will involve them in overseeing the performance of the obligations where the relationship has broken down, and the courts don't want to do that. Again, always topical, the examiner likes it. Rectification, simply asking the court to rectify the contract to reflect the true intentions of the parties. So a contract's been agreed and you say it doesn't truly reflect your intentions. What the courts will have to decipher is whether or not there was a mutual mistake, so both parties are in agreement that the contract doesn't reflect what they want, or a unilateral mistake. I am saying that the contract I signed does not reflect my intention. Obviously, there's a much more difficult burden on me to prove that because I have signed that document. So it's difficult and it will be played out through viva voce or oral evidence at the trial of the action. Again, always topical. Rescission, very important topic on the exam. What you're asking the examiner to do is rescind the contract and return the parties to the position that they would have been in had the contract never been entered into in the first place. Both parties have to be capable of being returned exactly to their pre-contractual position in order to rescind a contract. It is very important, and again, what you might be saying is there was some misrepresentation that induced you to enter into the contract, there was some mistake that induced you to enter into the contract, or there was some undue influence. And undue influence from the point of view of the exam is probably the most important aspect and arose a lot in relation to during recessionary times when wives were guaranteeing husbands loans, but there was nothing in it for them. Okay, they would ask that the contracts be rescinded, for example, because their family home was on the line. And again, there's huge amount of case law on that we deal with during the course. Equitable estoppel, this idea of it is not, or the court will stop somebody from resigning on their promise because it would not be just and fair to allow them to resign on their promise. Very, very important for the exam. Effectively what they're saying, or an example would be, your great aunt says, you come home and give up your big job in the city, come down to Donegal and look after me, and in return I'll leave you my house. You do it all, you give up your big job, you move down to Donegal, she dies and she leaves the house to your brother. Okay, she hasn't validly conveyed it in accordance with law. There has been no conveyance of the property to you, but proprietary estoppel may well kick in and the court will stop her from resigning on her promise, albeit that the conveyance either didn't take place during your lifetime or she didn't execute the will in your favour, which would also be valid in accordance with a valid transfer in accordance with law. The court will stop her because it's not just and fair, because she assured you she'd leave it to you, you relied on that assurance and you suffered detriment as a result because you've nowhere to go now, you've no job and you've no money. Okay, very important. Express trust, also important. We deal with things like the three certainties, does come up on the exam. Secret trust, again, very important. This is where a person basically creates a trust in a will and they were traditionally used to provide for illegitimate children. So they basically left their money to somebody, but the reality was that somebody they left it to knew that it was actually to be used for some other purpose. Again, very important in the exam. Purpose trusts are things like charitable trusts. Generally, the law doesn't like or allow purpose trusts, but in relation to charitable trusts, they're very topical on the exam, and it's effectively where you leave money to a charity. There is now legislation in place that deals with that under the 2009 Act, and we look at that in some detail on the course. Resulting trusts, things like the presumption of advancement and the property rights of cohabitants. Okay, again, very important. If you and your boyfriend buy a house together, he pays the mortgage, but you pay for everything else. Are you entitled to anything as a result of your contributions? Does anything result to you by virtue of those contributions? Trustees, again, where a person is created as a trustee under a will, what comes with that are rights and obligations. They also have powers under the, as a trustee, and we look at those during the course of the syllabus. Okay, that's basically a very, very quick synopsis of the equity course. From the point of view of the exam, as I said, it's not difficult. There's nothing complex about it. It's simply about getting your head around it, and that's what we hope to do during the 14 weeks that we have.